And the three of you that are on the one Zoom connection, if you could just say your last name if you speak, just throw out your last name or your first name since I have both when you speak, that would be great.
Sure thing.
Thank you.
Just gonna check, make sure everything's running here. Looks like we're all good to go. All right, so let's get started. So before we get on the record, I want to apologize. I got sick. I don't know, last night somehow I got a cold bug here. So I'm going to apologize if I'm sniffling, and I know my voice doesn't sound as it usually does, but hopefully we can work through this. I'll try to do my best to stay alert here, but I'm just really feeling under the weather. I don't know what this is, but hopefully won't affect the conference too badly. But if I'm forgetting something one of the things we usually cover, please feel free to remind me if I'm missing an item or if you have any questions. All right, so I think we have everyone here we're expecting. So let's get on the record. This is docket 9833 CE 100, the application of Fox Solar LLC for a CPCN, a Certificate of Public Convenience and Necessity to construct solar electric generation facility, battery storage, and also a generation tie line. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're here on Zoom with the parties and commission staff for a pre-hearing conference. Normally, pre-hearing conference, there's some set items that we cover, identifying the parties, the issues, the schedule, and any other matters that will facilitate the proceeding. So I'd issued in the notice of proceeding sort of proposals that staff has provided us, and also a document called Facilitating Matters Ordered in Contested Case Proceedings, sort of our standard filing and records filing and formatting document that will apply in this case to all the documents we're filing and sort of the procedures we use in these types of cases. So we'll go through those issues one by one, get questions, and hopefully give you some answers. It's important that we go through this process here especially because we have Town of Morgan as an intervener, and I think commission staff and the attorneys for Fox Solar are quite familiar with our process, but as Town of Morgan, I know it'll be the first time you're participating in one of these cases. So I want to welcome you, but also want to be able to provide you the information so that you can effectively participate and participate according to our standards. So it's important that we do apply the standards to all parties equally, but hopefully we can address any questions you have and be able to help you and facilitate your participation so that we treat everyone the same and get everything in the record in an appropriate manner. So first of all, just for the parties, we've already identified the parties, and I do believe I issued an order reflecting the request to intervene from the town. So in terms of the parties, we have Fox Solar and the Town of Morgan. And in commission staff, I just want to explain a little bit. So commission staff is a type of participant, and because commission staff and the Department of Natural Resources work together as they're mandated by statute to work together to produce the record in the case. I treat the DNR witnesses, DNR experts as if they were commission staff. So they're combined together, and the commission staff attorneys are the people that will be representing and introducing those witnesses in the case, sort of shepherding the commission staff and DNR through the process. So just want to let you know that ahead of time, something we do overlook in a lot of cases because people are frequently participating and they expect to see this, but I'm trying to be a little more upfront about and proactive about identifying the DNR as well as a participant, but those people are acting as if they're commissioned staff. So when staff files testimony, you'll see that there's certain filings will be presented by DNR employees. So I wanted to clear that up. I guess in terms of the parties, though, I did want to mention, I know that the town of Morgan being a municipality in the project area, I was curious to know to what extent are you planning to participate, and in what method do you plan? For example, do you plan to hire experts to present expert testimony, or and then as well as just how what should we expect in terms of your participation? I'm also guessing that you've had conversations with the applicant, and I just want to know what's the status of your relationship with the applicant, and are you working on reaching agreements in terms of what the applicant will be planning in the area, or is just a complete impasse and there's no communication going on between the two parties at this point? So if you want to just give us a little rundown, please. I think we have is it Lori
Yes.
with
Which one?
oh and I guess maybe okay. Well, let me I did skip over something, but we'll get your answer first, and then we'll go back to it. But yeah, I'm sorry, I'm just really not feeling my best. But go ahead, Lori. Just give us a little rundown of what your plans are in the case.
Okay, so my number one concern with Fox Solar coming in is the health, safety, and welfare of our community. Also our 20-year plan. And, along with that, there's multiple other, I guess, fingers, if you will, that we are concerned about. Let's see, we will be having, I think there's a few people, experts that we're going to be bringing in, and they have agreed to, I think that's a written document. Is that correct?
That's correct. Yes. So you'll
Okay.
need to get your testimony filed in writing according to our schedule, and we can discuss that as well.
Okay.
So,
Okay.
but you are looking to hire experts and present them as witnesses?
I don't know that I need to hire them.
Oh, I'm sorry. Yeah.
They've just graciously been kind enough to help us out.
Sure. I understand. Okay.
So, excuse me, this is Nelson Kispert speaking. And we also have, like ourselves who are going to be providing some, I don't know if you call it evidence or testimony, but right?
Yeah.
We're doing
correct.
some of it ourselves as well.
Yes.
Yes. Okay. That's great. That's good to know. And then in terms of your relationship with the applicant, I mean, are you still in conversation with the applicant? Is there a opportunity that there'll be some agreements, or in your mind, have you reached an impasse and you're not continuing on a conversation with the applicant at this point?
Well, we are in talks with the applicant.
Okay.
We have decided to do the joint development agreement talks just on our own. We will have, attorneys look at it behind the scenes. Of course, you have different language than we do. So we want to make sure that, everything's intact. So
Okay.
that's what our goal is, I guess, is to trying to come up with something. But are we going to get everything we want? Probably not. We tried to start last November, and we haven't gotten anything spelled out yet. So
Okay.
I don't know what that's going to look like in the future here. So
Okay, that's just good to know. And then in terms of hiring an attorney or having an attorney represent you as you participate in this proceeding, any plans on that line, along those lines?
like I said, we'll be having an attorney look at the ending part of the JDA
Okay.
and or this intervening process also.
Okay, so you think there will be an attorney representing you before me in this proceeding?
No, I
No.
think, no, we're just having them behind the scenes just to help us go through the process.
Okay.
But we're not, bringing anybody in, uh, um, I guess, to be, like, all of you are on the screen.
Right.
You won't see them, so.
Okay. Well, I would encourage you to think about hiring an attorney to represent you in the proceeding, because we do try to, well, we don't try to, we do adhere to, legal process here. And it does, although evidence is presented in writing, witnesses do appear at the hearing and are subject to cross-examination. So, depending on the nature of the case and how far along you get through the process in an adversarial sort of posture, maybe to your best advantage to have an attorney represent you here. There's legal standards and evidentiary standards, a lot of things that you're probably not familiar with that will apply to your participation here. So just in order to give you that heads up, I mean, your interest may be best served by having an attorney in the room. I'm not sure how having an attorney behind the scenes. I mean, I guess it's a limited form of representation. I mean, I guess that is allowed in Wisconsin, but I don't know how effective that would be. So just wanted to let you know that we are going to apply our rules and regulations and
Sure.
proceed in that way. So yeah,
So-
having someone who can understand that and translate that language to you is definitely to your benefit.
Okay, I appreciate that. Thank you.
Um, okay, and I don't know if what I failed to do, because I'm just like I said, I'm not myself today. We forgot to take appearances on the record. So why don't we, before we go any further, let's do that first. So while we're on the record, we'll just have the people representing the parties and staff identify themselves. We'll start with Fox Solar.
Good afternoon, Your Honor. I'm Jess Polakowski, Reinhardt Berner Van Duren, appearing on behalf of Fox Solar LLC. Also on the call today is Anna Galanis, who is with NextEra.
Oh, great, thanks. And the Public Service Commission.
Good afternoon, Kara Coons, Assistant General Counsel at the Public Service Commission, and with me is Taylor Sewell.
Okay, and for Town of Morgan, who's representing the town?
Good afternoon. This is Lori Wittoon, Morgan Town Chair.
Okay, thanks. So sorry about that. I took that out of order, but I just wanted to let people know it's another one of the details here. So the service list is something that you're seeing here on the screen. It'll be available on our ERF system. But it's important that when we get down to the facilitating rules in the case, when documents need to be served to parties and staff, this is the list, the service list. So these are the emails that need to be used for serving documents to everyone. It's also the list that we use for official commission communication. So if I'm issuing an order or when the commission issues the final decision, it'll be emailed to this list. So if you do need to make corrections or add people to this, there's a process for doing that. You'd file a request to modify the service list. So for example, if the town wanted more people to receive documents, since you only have one person there listed, I mean, it's perfectly fine if Lori, if you wanted to distribute what you're getting from us out to other people, but if you wanted them to be directly served, we'll need to add those people to the list. So
Yeah.
if you go into the facilitating matters order, the attachment here, it'll give you instructions on how to file that type of document.
Okay.
All
Yeah,
right.
thanks for sending that early for me to review.
Yeah, sure.
Helpful.
So I just wondered if the applicant had any response to what the town was saying there. I'll give you an opportunity to do that. It was just a kind of just getting a sense of the temperature here about the case.
Sure, thank you, Your Honor. I would just note, we do, I believe, have a meeting scheduled for later this month to discuss a proposed JDA. We remain hopeful that we'll be able to make some progress on that. But it does seem there is significant opposition.
Okay, all right. Sorry. Okay, well, let's move on. We can discuss more of the process once we go through some of these nuts and bolts here in terms of the issues in the schedule. But in terms of the issues, staff did propose an issues list. It's essentially listing a bunch of statutes and rules that apply to the case. It's kind of our boilerplate, our common issue that we use in electric generation cases. So I don't expect that we'll need to change that at all. It does provide the commission, it provides us direction in terms of giving us an idea of what statutes apply, what standards for review we need to address, but it doesn't restrict. It doesn't include any specific restrictions or specific items that people may want to address. But as long as they're included within the statutory standards, which the commission has to apply, the evidence that's being presented along those lines should be fine. So are there any questions about the issues list?
Not at this time for me, Woodtoon.
Okay. And you'll see, for example, things like health concerns, individual, or what was some of the statutory language is in 196.491 that the town may be most concerned about, which is regarding the environmental impacts and health and safety issues. So the standards are in that section, and so that's the language we're going to be following when we review those types of evidence in the case.
And
Yeah,
can I speak?
yeah. I'm encourage you to ask questions now. Yeah.
Okay. So do we also have to follow the PSC statutes? I noticed that you have some of those in there as well, and those have to be followed. Right?
Well, yes.
That's a whole separate thing from the state statute, correct?
So there's okay. Well, there's the statutes. So what's listed as WIS stat and then the section number, that's the Wisconsin law that the legislature has approved. And then the WIS admin code at PSC, that's administrative rules that the commission has approved. So they both have the force of law, and those standards all apply in this case equally. So yeah, what you're seeing listed here will be the standards that the commission will need to apply in the case. I'm not sure if I.
Yes, that's yes.
Okay. Okay, so in terms of the schedule, I know staff had issued the proposal, and I am aware that there's some counter proposals. Maybe some of the dates don't work for a number of you. I guess I was just curious. I did see that perhaps there's an opportunity to make a minor modification to the proposed schedule that I didn't hear that there were any conflicts on at this point, because and I'll let you know, commission staff. So I should probably let you know this right away. So commission staff does act as my advisor, so the staff attorneys and the staff that are participating in the case, I'm able to ask them questions and communicate with them. So commission staff attorneys did keep me abreast of the meet and confer and some of the dates that were being discussed about the schedule. So, and I guess I didn't see any proposal, and maybe there's a reason for that. But in terms of the February, a week in February, the second week in February being maybe a better hearing date for parties to attend. And I know there were some conflicts with the February 6th date.
Thank you.
And I was thinking maybe February 10th. Anyone have an opinion on that?
So our One of our key witnesses is not available on that date, so we could do the week of the 16th.
So the week of the 10th, week of the 9th is totally out. What about appearing on, but this is going to be a Zoom hearing as far as I know, and that still won't be available for Zoom.
I believe that's accurate, but I will, Anna, is that correct?
That's correct, as I was nodding my head.
Yes.
Okay.
Well, when we started,
Yes.
when the list first came out, I cannot meet on, what was it, the 12/18 date, December. So then the second list came out, which scratched that one, and we started at 11/19 and then went to 1/5, and that works for us.
Okay, so let me go off the record for this. So let's maybe I should give you a little more explanation of the process here. So the 12/18 date is not a date we'll actually be meeting. Is that maybe what you were thinking, that we'd be
Um,
No.
no.
Sure, go ahead.
This is Nelson Kispert speaking. We understood that the proposed 12/18 date was not a date for a meeting, but it was a date when we would have to have we would offer our evidence.
Right, that's right.
And we didn't feel that that date was workable due to some personal things going on.
Okay, so maybe we're not really going to use those dates anyway, but just so you know, I mean, it would just be the day that your written testimony needs to be filed. So it just needs to be filed by 12/18 at 1:30 p.m. So, there's time in between now and then to prepare your testimony and get it into the commission. So if there's a problem with that specific date, that might not be, sort of, a deal breaker, I guess, in this situation, because it's just a deadline to file your written testimony. It's not a deadline to be in person. So if you have a conflict with that exact date, there may be preparing your testimony, a little bit earlier. I guess that's something to think about. So the only time we'll actually be meeting would be that the party session hearing date. But having said that, I think we have another proposal out there. So the 16th it's a little bit, the problem is I have some other cases going on. Let me check my calendar. Didn't think 16th might actually work. 16th, okay. What's going on? Double check something here.
Excuse me, Judge Newmark, we're not seeing any other dates on the screen, and we don't see a 16th date in the schedule that was proposed. We're not really sure what date you're referring to.
The applicant had suggested the 16th. So I'm looking at that. Is that something, would that be so the week of the 16th
February?
of February, yes. Is that something you'd be able to make?
So that February 18th is what she sent over.
Yeah, I don't think the 18th is going to work for me. I'm just trying to find it on my.
Oh, that's what you're trying to, okay.
Let's see. Oh, well, there was going to be.
And just so you know, Your Honor, we can see your screen.
Yeah, I know. I'm just thank you for mentioning that though. Okay. So I think week of the 16th is available. There's just a lot of cases all kind of starting to line up in February, but none of them have been settled. Well, a few of them are settled and some of them aren't. But I think week of the 16th will work. So what I would propose is that if we could set the party session for the 17th of February. I think that would be the best time for that. And then in terms of the rest of the schedule, I mean, we could leave it as it is and just, have some space between the filing deadlines and the testimony, the testimony deadlines and the hearing, or we can adjust it accordingly. But how does the 17th sound for everyone?
Is that the same time?
It would be 10 a.m. Yeah.
10 a.m.
That works for applicant, Your Honor.
Okay.
To what? 17? Yes, that will work for us.
Okay.
And that will be, just to confirm, that will be by Zoom?
Well, let's discuss that. I think given that we only have a few, two parties and staff, it's probably we could probably accommodate a Zoom only hearing. I think it would run well without necessarily bringing everyone into Madison. Any opinions on that from the parties?
We're okay with that. Are you
We're good,
okay? Yeah. Yes, I think we are. We're okay with that.
Zoom only.
Zoom, yeah.
Zoom only, yeah. Okay.
That
Yeah,
works.
that'll work.
I'm just checking really quick with staff to see if that date works.
So we're gonna start out with the 11/19. That works for everybody, and then we're gonna go to January 5th.
Yeah, we can discuss that. We
Yeah,
could
okay.
possibly give you some more time, push things forward a little bit because
Okay.
there is that extra time now. Okay. So usually this deadline, the corrections deadline is usually about a day before the hearing, or it could be, a couple of days before the hearing. So if that was now going to be the 16th or slightly earlier, we could back up or we could move forward the other dates. They got it.
Mhm.
Any word from staff?
Just a second.
I mean, I'm not expecting that's going to be an issue. I think staff's going to have to, they're not here to tell us.
Yeah, well, Heather is on the call, so
Okay.
she's just confirming with.
All right.
Okay, so you were suggesting the 17th,
Yes.
February 17th. Okay, yeah, but she was trying to talk with Chang, but he's not available, so.
Okay. Well, they're going to have to make that work. All right. So we're just going to back up from there. Excuse me. We could do um, the corrections to testimony on the 13th of February, or we can do it on the 16th. It doesn't really matter. But I would propose surrebuttal on the 12th of February. And then back up from there using the same intervals. So looks like that puts us at the beginning of the year for rebuttal. Basically the 8th of January.
That's for intervener and commission staff.
Rebuttal. That wouldn't be that early, right? No, rebuttal would be parties and commissions, all the parties.
Mhm.
So rebuttal the 12th, so it'd be a week later, really. Be like the 15th or the 22nd, correct?
For Sir rebuttal?
Or, well, I was thinking rebuttal on the 12th of February. We're moving everything forward. Is that okay?
Yep.
I mean, it's really not my concern. It's up to you guys. That this part of it, if you guys want to agree to something, that's fine. So I was just kind of going to use the same intervals,
Mhm.
but move things forward, or we can leave it where it is, or we can adjust it differently. It's up to you.
Are we talking, excuse me, this is Nelson Kispert speaking. Are we talking about the rebuttal now or the Sir
Well,
rebuttal?
all of the written testimony deadlines. So if we set, for example, we set rebuttal on the 12th of February, then we'd push the rebuttal a week forward to the 22nd, or I guess it'd be the 19th.
Or the other option would be just to leave the testimony as is and then just have a break
Yeah, that's
for the
fine.
hearing.
However
I'm
people
fine.
want
I'm fine either way. I have no strong preference.
to. Okay. How about the
Excuse
town?
me? Oh.
Yeah.
Excuse me. I don't want to.
Go ahead.
I was actually, so the date, and this is Nelson Kispert speaking, by the way. The
Okay.
date that we were concerned about was, at least I was concerned about, was the 18th.
Right.
Just because we wanted to allow, I mean, because you've got the Thanksgiving holiday there, and then
Okay.
you've got Christmas in there. I was trying to get that pushed farther into the future to allow for that time for the holidays.
Oh, so have it past the holidays.
Yes.
Okay.
I'm just a little concerned. I want to make sure that we maintain adequate time for rebuttal. I'm fine with the intervals that are set forth. I just want to make sure those are retained.
Right. Well, when can you have your direct filed? Actually, Attorney Polakowski.
The 12th is reasonable for us, November 12th. I wouldn't want to do any earlier than that.
Okay. Well, if we're going to skip the holidays, I mean, there is more than a month for the intervener and commission staff direct, and there's the Thanksgiving holiday. But there's still time, I think, to present your direct. So, and let me explain. Possibly this may be helpful. That so for the direct of the applicant is going to be the evidence that the applicant believes supports its case, and and all of the information it believes the commission should have in order to review the application. And then the direct for interveners and commission staff is the same for you guys. It's to present your case to the commission, and that may involve asking questions of the applicant and getting responses back. So that is something that may take time, but that's something you could start doing, something you could have started doing as soon as you were made a party. So at this point, you could start asking questions and getting information in addition to what the applicant's already provided. In the application and all the other documents it's filed on our website. So there's already an opportunity now to start, presenting your case, gathering the information and putting it together in terms of your view of the application. What's wrong with it? How could it be improved? It's not what you're doing in your direct is not necessarily responding to the applicant, but you're presenting your side of the story proactively. So it's rebuttal is your opportunity then to respond to the applicant's direct and say, hey, they said it's not going to affect, this plan that we have for this piece of land, but it really is. So now we're going to show you why. And so, so the direct itself, it's not that you need to wait for applicant to respond and you're not responding to the applicant in your direct. You can start making your case now that you want to present to the commission, have it ready for the 18th. And the response to the applicant's direct is really technically can be done in for the next round of testimony. So, if there might be some concern about, that you don't have enough time to get your case in chief in by the 18th because you need to just be responding to the applicant, but that's not how it works. So, so at this point in time, you can start, reviewing the application and asking questions to the applicant, getting those responses now and formulating your direct at this time. So that's, essentially, several months in order to prepare that body of evidence. So I don't know if we can push it because the next week is Christmas and then after that's New Year's. So we're pushing. We'd have to push that date 3 weeks ahead, and then we'd have to shift the rest of the schedule. So I don't know if there was a proposal to push the hearing, it would have to be at the end of February or beginning of March instead of what we have now, sort of mid-February. So I'm not sure if there's other people interested in pushing that deadline past the holidays. Was that something that was being proposed?
No, the original dates for the testimony work for staff. And the hearing it's fine for us to have that gap. I also kind of get worried if we go too far into the new year, because then we'll have the same issue if stuff is due right after New Year's.
Yeah, I agree.
Excuse me, this is Nelson Kispert, a judge in Mark. Can I ask a question?
Mm-hmm.
So is there a statutory reason why that date could not be pushed into January? I think at one time there was a January 5th date put out. Is there a statutory reason why it couldn't be pushed?
It's not a statutory reason, no. Where is that proposal? I did see that proposal somewhere. Cara, do you have that available?
I have to go back through. There are a lot of emails.
Mm-hmm.
I'll get it sent over. This is Heather Young.
Okay, thanks.
The problem from my perspective with that proposed schedule is I think that 17th hearing date wouldn't work with that schedule. Things would get too condensed.
Right. Yeah, that's true. Yeah, we would have to change the hearing date for that.
Yeah.
Okay, so let me share this. So the trick here would be March 2nd.
Yeah.
Sorry, my screen is smaller than usual.
Yeah. I mean, the January 5th is really, you're gonna have to do it probably much earlier because you still have the holidays, like New Year's Eve, New Year's Day, Christmas Eve, Christmas Day before that.
And the Switoon, I guess I noted that early on,
Mhm.
and this doesn't really mean anything to anybody else, but I have 2 people right now that I'm caring for end of life stuff. So
Right, I
it's gonna
understand.
be the last holidays, if you will,
Right.
that I'm able to spend any time with them. So that was part of the reason as well.
Well, you would get, if you had the 18th, you'd have it all ready and done. So that might,
Oh, wow. Yeah.
that might be something to think about. But I mean, I have the March 2nd is available for a hearing. So let me just make sure I got the day for that. Okay, I prefer on the 3rd, so we just shifted to the 3rd. But then really with that, we can then move those deadlines further forward because there's a big break there. So I mean that's another thing that would give more time for the case. So that's oh, someone's raising their hand. Heather, you raised your hand?
Yes.
Oh
So
yeah,
Team
go ahead.
Work.
You can
Um,
check, just chime in. It's okay.
thank you. Later or earlier in this email, staff proposed some pushed out timelines for applicant direct, staff intervener direct. It's coming from Chang in like a blue box. We keep scrolling, which I think would, yes, here, which kind of would close up that gap. So just wanted to point that out. Thank you.
Oh, okay, I see. Sure. So does this mean applicants direct would be either the 19th or the 25th? Is that what
I think he was hoping to push it out from the 19th to the 25th and the 5th to the 12th, respectively.
Okay. Oh, there you go. Well, what do people think about that? That gives everyone a little bit more time over the end of year holidays. And then well, still surrebuttal on the 18th. There's still a lot of time before March 2nd. So
I think we had, those dates were okay with staff, because Chang had proposed them and we had run them by everyone, but
okay.
And is this, would we keep the hearing at the 17th or the 2nd?
Well, it would have to be it would have to be after the 18th for sure. Let's see. And
Yeah.
I could do the 24th. Or even, oh, I think I could even do the 19th. Let me just double check other calendar here.
I'm a little uncomfortable only having a day with the surrebuttal. That might be a little tight. I'm fine keeping it at March 2nd, I suppose.
A day meaning between surrebuttal and the hearing?
Yeah, yeah.
Oh, okay. I mean, that's pretty standard. That's what we, well, maybe, I don't know, what we've been doing lately in I guess staff has requested a little more time than we used to. So yeah, that, I mean, March 2nd works. If having that break works for people, it's fine with me. So,
I think that's fine with me, Your Honor.
all right. So how does this sound then if we did the applicant, so applicant direct, you we guess you don't have to file until the deadline, but as you said that that November 12th you'd be ready, but
November 25th, that this proposed schedule is fine for us. 25th, 12th, 30th, 18th.
okay. But I guess if you think you could get it in earlier, that might be good just because we do have a new party here that really hasn't done this before. So if you're okay with the 12th, why don't we do it the applicant direct on the 19th and then take the other dates, the Chang recommended changes here.
So is that the 5th or the 12th then?
So you would have the 12th, so it'd be 12th for staff, intervener and staff direct. 112. Rebuttal would be 130. Surrebuttal would be 218. And then we have the hearing all the way out to 3/7.
March 7th is a Saturday.
Oh, no. Wait a second here. Okay. You know I'm not feeling well. Okay. You're right. What was I thinking?
I think the 2nd or the 3rd is what we previously said.
Third must be, oh yeah, so that's fine. I don't know why I was thinking that. Third, let me just, so I think there may be a potential conflict. That was the problem. No. No. Okay, yeah, I think the third will work. Okay, so 3/3. All right. The rest of the dates get set. It's an operation of how the facilitating matters order works, just in terms of the timing of the refilings and the transcripts. So it's just a mathematical operation. I can just extend the deadlines according to that. So we don't really need to discuss all of that, but so does that work for everyone then? What we were just discussing?
Yes, works for applicant, Your Honor.
How about the town? Good with those dates.
Go ahead.
Do we land on the March 2nd or March 3rd?
March 3rd. Yeah, I'd prefer not to hold a hearing on Monday because for whatever reason, we're never all on the same page after the weekend. So it's good to have that Tuesday hearing.
Thank you.
All right.
Yes, that works for the town. Thank you.
All right. Well, thank Chang as well for save the day. All right. So let's get on the record. I will just detail what we decided here. So we did discuss the proposed schedule and came up with something we can all live with. So we'll have applicant direct to do November 19th, intervener and staff direct January 12th. I'll just make sure stop the record here.
Lay down. Lay down. Lay down.
Let me know when you're ready.
Oh, I'm sorry.
No, you're
I
good.
thought I was on mute.
No, it's okay. You all have to deal with that. Ready?
We don't all
We
have to
had,
deal with dogs.
I do. January 12th is intervener and staff direct. January 30th, rebuttal. February 18th, surrebuttal. And March 3rd will be the party session on Zoom only. The remaining dates I'll just fill in according to the facilitating matters order directions. So let's now move on to facilitating matters. So I know, Laura, you said that you seen the notice of hearing, and attached to that's the proposed facilitating matters. So it's our standard language. So just so Jessica, you know that I don't think you've seen this version, or you probably haven't been in a case yet with this version. It has been updated over the summer, and the cases that you've been on, it wasn't applicable yet. So format of the documents changed. That's kind of like the biggest thing, that we adjusted the format, and there are some reconfigurations in terms of like making requests, the deadline to file objections to testimony, um, and just formatting changes. And I've tried to make more examples and uh, be more explicit with templates at the back of the document. So for people who don't get to don't have the pleasure of participating with us that frequently, hopefully this document can serve as, as well as the guidelines, the standards, but also as a guide for how we proceed. Um, and for example, looking at the testimony, um, written testimony, there's sort of an explanation here as to what we're talking about when it comes to that there's rounds of testimony, and we label them direct rebuttal, surrebuttal, so that parties can get an understanding of what this all means, and how it's defined. So um, that's how we've, the new structure of the FMO, we call it the FMO, and you'll see that being referred to as the FMO. But if there's any particular questions, maybe more globally, or any specific issues you see from the town, and from the applicant, anything that comes to mind now, I can address specific questions, or I can just give sort of an overview depending on what you need. So
No questions here, Your Honor.
nothing. Okay. How about with the town? Anything that comes to mind right away?
Oh, this is Nelson Kispert.
Yeah.
I do have a question, and I apologize if seems very remedial.
No,
But one of the things that I've seen with the evidence that's offered is it's always a question and answer format.
yes.
And I'm having a problem understanding where are the questions coming from? The questions coming from someone else, or how does that work?
Okay. And so let's go off the record for that, because it's not, I don't think we need to record this part. But so what we're doing is we're trying to create in a written format the sort of mimic what would happen in a trial. So where you'd have a witness come take the witness stand, and then the attorney ask those questions for the witness to answer. You just have to imagine that's happening in writing. So if there's a certain point you want to make in your testimony, the testimony gets divided up in questions and answers rather than just being a long narrative. So the question can just be like introducing the topic, like, you're a witness, you lived in the town for 20 years. So your question might be like, well, what do you think, how do you think this is going to impact your property or your view of that? Or let's see, say the witness has a concern about the view that they'll have going down a certain road that they take every day. So the question could be something to that extent, like, how do you think this project is going to affect your drive on Highway X? And then the person can answer, well, I take this road every day, and it's going to disturb the view, and this is how I feel about it. So it's just to give sort of an introduction to the answer. There are many examples of this well, I do provide that template, and although it's probably not artfully done, so at the bottom of the FMO, there's sort of a example that you can use, and you can use this to create your own testimony And we also have a Word version of this that I can send you if you'd like. So then you can really just use it to fill it out using this format. You could fill out, in the boxes here, put your information in. And also, you don't need to you're not bound to using these questions or answers, but the idea is just to give you an idea of what it looks like. So, but if you wanted to, kind of fill out the beginning, which talks just about introducing the witness, getting their credentials and their experience, and then really just having them go through their position on the project, but just breaking it down by using those questions. So like if they have a variety of issues, like, well, I have an issue with the project crossing a stream, and I have an issue with the project being proposed on agricultural land. So the question could be, you could break that up, saying, well, what's your concern about crossing stream, the muddy creek, and then you have the person answer that. And what's your concern about how the project is proposed to be on the corner of this busy intersection? Like then the person can answer. So it's just to give sort of a break in the narrative.
It was very helpful. Thank you.
Okay.
Most definitely. And could we get that Word document template that you referred to?
Yes, I'll email that to the service list, and people can just, yeah, it should work. So I have a Word version, and I can also send it in a more generic, I can't remember the name of it now, but if you use like an open source. Well, let me ask, if you use Word, it should just
We
work.
do.
Okay,
Yeah.
Aaron's shaking your head. Yes.
Clerk
Okay.
Morris here. Yes, that or a general TXT format is typically helpful.
Yeah, I think there's an ODT, but
Okay,
okay, all right. Well, I'll send you the Word if it doesn't work.
word's sufficient.
Word would be great.
And so then the other templates here. So the back of the FMO does show you other templates, and these are okay. So these are appendices. So this one's a request to correct the testimony, Appendix B. So that's referred to in the FMO and how you would want to be able to request a correction. And then if you have the Word version, you can simply fill it out and then file it. So that's how that would work. So then it does cover many, maybe not every, but many different varieties of what you would need to file in the case. So that's good. So then as you go through the process, like I said, there's the written testimony description here, section 3. It does identify that the testimony gets sort of narrowed in scope as we go, where you're presenting your full presentation to the commission in your direct, and then for rebuttal, you're responding to what's being offered by commission staff and the other parties, if this is the town. But and then it gets more and more narrowed. So the rebuttal is a response to direct, and surrebuttal's response to rebuttal. But you don't need to repeat everything. I mean, if your position doesn't change and whatever the other people have said, you don't necessarily need to refute it all. You could just say, well, the way the FMO operates, if you say nothing, you haven't agreed to anything else. So your position hasn't changed by your silence. But if you want to just say, I've read the applicant's rebuttal and my position hasn't changed, and that's all you really need to say if you think you've covered it all in rebuttal. Otherwise, you want to address the specific statements in the rebuttal as your surrebuttal. And you want to be able to avoid introducing new topics, new issues as we're going through the rounds of testimony. So, if it's obvious that one of the issues may be that the project isn't compatible with the town's land use plan, that issue should be presented in direct. It shouldn't be introduced for the first time in rebuttal or surrebuttal. So, there may be some nuances, there may be new information that you need to use to respond to the rebuttal. to the rebuttal, say. So, but you shouldn't be introducing an entirely new concept after your direct. It all should be presented in your case in chief.
Okay.
And that just helps for you. And that's why the rounds of testimony the interval gets shorter, and the length should be shorter. It doesn't happen all the time, but then as the case speeds up, there's a reason why that occurs, because really we should be narrowing the focus and being more succinct, and you're just debating what comes up from uh, the rounds of testimony, what issues sort of stick out in the process.
Your Honor,
Yeah.
we're having a little audio, something happened where the last bit of what you said was
Your internet connection.
gargled.
Oh no. Okay. Anyone else experience that?
Maybe it was just our connection.
Okay, maybe it was just our internet connection. I'm
What
not
I'm
quite
gonna do
sure.
is send someone outside. Okay, that'll help. Sorry about that. Okay. Yeah, let me know if you have any problems, more problems.
Thank you, sir.
Okay. So yeah, so you'll get the templates. That'll be useful. I think what I know you filed the request to intervene on Earth. So and we have your emails, so that should work. So just so you know that the participation, anything that you file, you should also serve to the service list. And something I make it that probably gets overlooked, but I could show you, is that there is a way to find the most recent service list on our website. So I'm gonna just direct you to our homepage, and okay, it's kind of a small version of this. Let me. So, okay, so to get documents in the case, you've probably seen this already. Sort of our one-stop shop for the docket itself is this docket search case management system. So if we just enter
Very familiar.
the docket number, it's all you really need, because there's no other docket in this for this utility number. So that's oh, and wait, yeah, that's good. So this is the public version of our case management system. To see who is on the service list, if you look at the documents tab, you can export the active service list to Excel. And I'm sorry, that's the only way IT could do it. So it's kind of annoying, but that's what we have. So that's your service list. And so it may change over time, but all those requests to change the list should be filed on IRF. So you can follow along. But if you really just want to have the latest list, that's how you would grab it.
Okay.
So yeah, go ahead.
So we are in there.
You
Oh,
are, yes, Town of Morgan. Yep.
okay.
Yeah.
Okay, so our request to intervene is there, and I was just asking Erin if she could enter that in there, but apparently it's already there. So
Oh, yeah. So yes, yeah, you wouldn't have, yeah, you're on the list. So you could also look for documents. So if you can look for all the documents, but you can also look for specific document types, so the request to intervene. So this page is now our IRF system where all the documents are located. And we have your Fox Solar intervention. That's the document you filed. So that's
okay.
another website we have, but it's connected to the CMS. If you do want to get to directly to IRF, again, it's e-services, electronic filing system, and the easiest way. So you can put in the utility ID, and then you could pick any of these document types, or you can search the whole thing. So you'll see on the FMO that there are certain filings get filed using certain document types, and then there's a certain naming convention for the documents, and all that's spelled out in a lot of details in the FMO. And there's no, I mean, I'm not going to reject the filing if it's filed incorrectly on those with those, if it's not formatted correctly or if it doesn't have the correct naming convention. But it's going to mean that I'm going to have to review it and send you a correction and have you refile. So the the best you can do to get that done right the first time, the better is for everyone. Um, but for this, if you wanted to see all the documents, you just hit go and you see everything filed in the docket. And there is a way to subscribe to IRF. Let's just go back to the home page using. Oh, yes. Okay. So the main page for IRF gives you this IRF Easy Subscribe. So you just need to if you put your email, the docket number, and then your email address, you'll get a verification code. And then once you have this set up, you can choose what documents IRF can send you a notification by email when a document is filed. So you should be getting those documents served to you, but as a backup, you can have a subscription as well. Problem is you'll get the documents by service before it gets posted to IRF and accepted on our system. So the emails are faster, and the reason so parties have always desired to get email service just in case something gets delayed as to getting when it gets uploaded to IRF and put on the system. So,
Okay.
but it is a way just to get a backup of our stuff that gets filed. So that's some of the basics, just navigating the pages, and you'll be able to see how that works. FMO also does give you some advice in terms of who to look for help. The records management unit at the commission can help you with filing, and the commission staff attorneys can help you with formatting issues, or they can't give you legal advice, but they can help you sort of navigate the FMO, because like I said, the FMO for the most part is, it's non-substantive, and we won't penalize you if things are not formatted correctly. We'll just have you make you refile. There are some deadlines that you want to be aware of in the FMO that are important. Make sure that you file your documents on time, and that if there's a motion to strike some of your testimony, there's a deadline to file a response. And failure to file a response on time will basically renders the approval of the motion. So you want to be on top of that if you do receive a request to strike your filings. And here we go. Okay. So that is all contained in the Section 5 request for an ALJ order. Gives you sort of a rundown of what general categories of requests exist, and you can make up other ones too. And then sort of the format of the request and how to file, and also the required, it's in special consideration. So if you're not responding to a request, it'll be approved essentially. If everyone does agree to a change and you file a request, it's useful if you could just state in your request that everyone agrees. And then the request actually just goes into effect upon filing. If there's any dispute, then we'll just wait for a response. I'll need to wait for a response before issuing an order. Also, ALJ communications. This is a good one for. So I shouldn't be receiving emails from you unless it's authorized in the FMO, or I've invited your response. So if there's something wrong with the filing, I may just say, hey, can you refile this, and then, you can let me know that you understand and then I'll say, like, can just respond to me if you have any questions. You can then respond by email, but uh, try not to have one-on-one conversations with parties. And if we do end up getting into some email chain, I'll just be responding to everyone, just so you know. But um, but the FMO does have some instructions of when I should be emailed for certain things. Otherwise, it's only if I'm requesting a response from the party.
Okay.
There's some of the pitfalls. I don't know if anything else comes to mind.
Excuse me, Judge Newmark, I had a question about discovery.
Yeah.
So, is the information or the documents generated in the discovery process, are those considered part of the actual case itself, the contested case, or are those outside of that?
Okay, that's a great question. Um, so if you go to section 4, it talks about exhibits. So I mean, testimony is someone's statement. So you can, especially if you have an expert that can rely on their expertise, they've read all the documents and they are giving your opinion. It's not necessary that they file exhibits to back that up, although it would be very helpful and it'd probably make their case a lot more credible. Um, so that's a strategy. That's up to you guys. But if you want to present documents to the commission, let me back up even more. So the commissioners who make the decision can only review what's in the record in the case as the basis of their decision. So what this whole process is doing is it's creating that record. So I'm kind of the filter to make sure we provide the commission evidence based on our evidentiary standards and hopefully nothing else. So, and then they can only use that information. So they can't, so they'll meet an open meeting and they'll make a decision. They can't say, oh, I just read in the paper that such and such just happened, or I met this guy on the street and he said, there's a reason why we should approve this project. They cannot use that information. It has to all be vetted. It has to all be presented in an orderly fashion according to statutes. So this is that's what this process is. So by introducing your evidence in writing, so you could have your testimony and then exhibits that back it up. So if it's a data request response, an expert could say, I received information from the applicant in a data request, and I don't agree with it, and then describe why you don't agree with it. The document itself, if it's important that you want the commissioners to see that response, then you need to offer it as an exhibit. Just because it's on Earth doesn't mean it's going to the commission, because it has to go through the process of being offered and then received. So to offer it, you'd file it as an exhibit, and then through the process, I'll either receive it or I won't. So there may be reasons why, it shouldn't go before the commission. Most data request responses, it's appropriate or discovery. It's usually appropriate that the commission see it, but there are some chance and reasons why there may not be, may not meet our evidentiary standards. So it has to go through that process. So any documents that you want the commission to see need to be offered. And you do that is by creating an exhibit, and essentially it's just putting the cover page on top, giving it the correct exhibit name, and filing it as an exhibit on Earth. And then it should tie back. It should be introduced in your testimony, and then you would want to give it some sort of context. Why am I giving you this document? And that's part of your testimony. Like, why is it important? How does it relate to my argument? How does it back up my position? You want to tell the commission that, and your opportunity to do that is in the testimony when you're presenting it to the commission. There are some tricky things about exhibits. Some things that we call them special exhibits. So it's because we do collect a lot of information on Earth, we don't necessarily have to repeat and refile every document. And there's certain documents where we've kind of done a shortcut. In particular, the data request responses that staff issues, or the data requests that staff issues and the responses that staff gets, they all go in the record in this case, in these types of cases. And what staff does is it creates a special exhibit that basically it's just a list of all those documents in its own exhibit with links to the original documents. It's just a way to organize that. So there's an example. There's some links in the FMO and examples to show you about those. Here they go. So Appendix D shows you the types of special exhibits. So this one is commission staff data request responses. Sorry. And they look like, so that's just the standard format that we do in these CPCN cases. And you'll see the cover page, and then it's just basically a table with all of the responses that staff received. So these are the responses that staff sent out, and it got a reply from, usually it's the applicant. Staff, I think rarely, it's very rare that they're asking the interveners for information in a data request. But so all these documents are in the record, and they can be cited in your brief, and the commission can read in order to make its decision. If you have your own data request, your own discovery responses that you want to put in the record, you'd want to, usually it's just a few of them, so you can create a new exhibit, and you just attach the response to the cover page and say, well, this is my exhibit one. It's when I asked the applicant about this topic, this is the answer I got, and this is what I think about it. So that's what would be reflected in your testimony. There's a couple other special exhibits you can review the FMO for that, but it's helpful just so you know you have a heads up as to what these things are, and you'll be seeing them filed over time in the course of the hearing. So just keep that in mind. Yeah, if it's on IRF, it's not necessarily going to be before the commission. Everything has to get offered and received for the commission to see it.
Again, very helpful. Thank you.
Okay. And they also see a document in the process called an offered evidence list, and I think I have one here. So that's going to be that's probably useful to review. Okay, I don't know if I have a link. Let me just show you one that I'm working on. So the offered evidence list is a document you're going to get before the case, before the hearing, slightly before. There's some time now, so I'll actually probably get it out earlier than usual. Here's one in a recent case. So it's going to lay out all the documents being offered for the record prior to the hearing. And that'll give us an idea of what's going in the record, and we could double check that at the hearing, make sure we have all the documents we're expecting, and you'll see notes in the document about any filing requirements that need to be corrected. So we call it the offered evidence list, and you'll get this by email of maybe a day or probably a little bit sooner than usual, but a few days before the hearing. So this was an MG&E rate case, but it's got the applicant and then it's witnesses listed, all the filings the witnesses have offered for the record by witness. And then it's got the parties, the interveners, and it does the same for them. And then commission staffs at the end. But it also has these comments, which will show you where your filing may be deficient and needs to be refiled. So for example, this guy failed to put the cover page on the exhibit. So there's just a note, hey, you failed to comply with FMO 4B2, you need to refile. And then when you refile, you need to refile according to the refiling standards. So all that's in the FMO.
Mhm.
So something like that's not very, it's not essential. There's a specific deadline to refile your documents. There may be more complicated reasons that you'll need to refile. Hopefully, I can get those comments out to you before the next round of testimony. So if your direct isn't meeting the standards, and we can correct those before you file rebuttal, so you don't repeat the same mistakes. But that's all I intend to get that through. But the press of work may not make that a reality. So hopefully I'll be able to catch those mistakes before we repeat more. And then at the end of the case, I convert the offered evidence list to what's called a received evidence list. And this case is just ending. So this will be put on IRF once it's done. And this essentially is a roadmap that the commissioners can use to review the record. So they know if I did it right, these are all of the corrected documents that have been received into the record and are available for the commission to review. That's only the evidence. So there's also the briefs that you file and the transcripts of the case. They're also available to the commission for making their decision. So basically, it's just some of these were refiled. So Stevens, let's see if I did that right. Yeah, so now we got our cover page. And I can accept the document. So that's how that works. So that's kind of what you'd be expecting there. And also in terms of discovery, FMO does give you some guidelines there in terms of deadlines for filing. Deadlines for responding to discovery are in there. And also there's requests for an ALJ order with respect to discovery. That's also outlined in the FMO. Right. Anything else comes to mind?
So we can get into a different case and view all those documents as well, just to see how they're formatted and
Sorry. Yeah. Oh, yeah. Well, on IRF, you can get into all of our cases. Yeah. So, yeah, I would just recommend if you want to get more of a get more familiar with that.
okay.
Yeah, we can. So one of the things with IRF, let's see, let's just go. This is a different view. Okay, so one of the things about IRF is that you could, if you want to see what testimony looks like, I mean, you could just say, well, what testimony was received from from May 1st, and then IRF can list them all for you
Oh,
in
okay.
every case.
Okay. Gotcha.
So that gives, and then exhibits the same way. You can see, just a wide view of different exhibits, different pieces of testimony to get familiar with everything.
Okay.
Yeah. Okay. All right. So anything else?
Do you have any other questions? Okay. I do have one other thing. So at the end,
Yeah.
so you've got our testimony, everything, things have been, I guess, squared away as we funnel through the ending. How does it work to, I guess, the solution or the end game? Who is the one that actually makes that decision then? Is that you?
No, actually, thankfully not. Um, I can, so the commissioners are the people who run our agency. There's three of them, and they've been appointed by the governor. And I'm not sure if you could help me out, if anyone knows if if some of them or all of them confirmed by the Senate. At this point, I'm not aware of that, the status of that. But it's a statutory appointee that has the role of running the agency and the responsibility to make those decisions. So, trying to find my homepage again, but they are listed on our website. You can see their names and background. Here we go.
Yeah, Miss Strand, I think
Yeah.
was
That's right. Yeah.
the other two.
Here we go. Yeah, there they are. So
It
they're the
looks like, according to Google, Your Honor, it looks like Chairperson Strand is the only commissioner who has been confirmed thus far.
Okay. Yeah. Thanks. So the commissioners will meet in Madison in our open meeting room. So it's available for anyone to attend, and it'll be live streamed on our YouTube channel. And they will go through the issues in the case, and they will be deciding, up or down on the various issues, whether the project has met the statutory standards, and then in the end issue a final decision that says, yes, proceed with this application under and with conditions or modifications, or no, we deny the project, go back, do some, go back to the drawing board, I guess is one way to view it. Once they make that decision in open meeting, then a written order will get drafted. Usually that draft gets sent back to the commission for its approval. They'll vote to approve the final decision, the written decision, just so they have a final chance to review what it says. Depending on the nature of the case, there's some cases, some smaller cases where they don't review the document over again, but I'm not sure what the plan is here. I would expect them to see that one more time. And that session then is just, people can come just to observe what they're doing. There's no public comment session. And actually, I should also review the public comment process. It's probably useful. So do you have any other questions about the commissioners?
No, that's good.
So I should this is probably something I should have done earlier. But so what's important about the case here is, as a party to the case, you get the opportunity to present evidence, expert testimony, and substantial information that the commission can weigh when it's making its decision. So there's benefits to being a party for sure. Then there's also the downside is you're sitting here today listening to me talk for one, and you have to go through all this procedures and process. But that's why we have there's multiple ways that people can participate in these cases. So there's the party way is the hard way, but there's benefits to it, as you've probably realized. The easier way is to participate as a member of the public. Then you're not, there's a lot less scrutiny in terms of the statements that are made. And it's what we're expecting to get from a member of the public is their opinion on the case. We hear a lot of emotional, descriptions of how they're feeling about it, what it's doing to them personally, and some very moving and important information. But it's rarely, there's rarely the technical aspect to it where people are analyzing the documents and providing alternatives or rebutting specific, technical aspects of the case. that's what really the party session is more more appropriate way to do that. But as a party, the important thing to do, and I think it's benefits for everyone in the fact that parties can only participate as a party and not as a member of the public. And members of the public can only participate as members of the public and not participate as a party. And the division, why we create that division is because of the procedures that are involved. So, but what's important is that it's because the town is participating as a party, anyone who wants to speak on behalf of the town as an entity should be filing testimony in writing. So anyone who wants to give their own personal opinion about the project, how it's impacting their property, their opinion on the case, with respect to their individual capacity, I can accept that as a public comment. But when it comes to the town's position and the town's, presentation, that's going to have to go through the process. So, when it comes to, what we'll be doing for the public session is we'll be holding a public hearing in the area of the project. We'll just need to find like a community room. Can't use the town hall because you're a party, so I won't do that. But I can find. I think I actually found something already, but I can't remember what it is. But there's some areas, some places we can hold a meeting, and we can invite people to come and give their comment. There's also will be an opportunity to file comments in writing, and that can be done on the commission's website. So you don't have to be there. You don't have to mail. You don't have to write anything out. You fill out a form that we have online. You can mail a comment to us, or you could attend the hearing, but then write the comment on a form and hand it to us rather than speaking in public. So those are different ways the public can participate. And encourage people to participate. There's only the caveat we kind of keep finding a problem with these cases is that I need to make sure that comments are from individuals, real individuals, and have that I have a comfort level that they're speaking on their own behalf and that they're they're not robots or some sort of a paid representative or something like that. So I need to just have a comfort level that I have real comments from real people. And to that end, we do have some guidelines in our notice of hearing, and that goes out to the public. So it's available for the public to view. And it's really directed to the public. It's not really directed to parties because parties shouldn't really be involved. The public has an opportunity to participate and just get a public notice, a hearing notice up on the screen. So the hearing notice does give some guidance for the public. Very slow. Okay, so here's case that we've had recently. And so just so you know, so there's opportunity for the public to, so we had a public hearing in this case. They could show up in our hearing room. They could join us on Zoom. They can call in if they don't have internet. And that's how they can attend the actual public session. For the party session, we're all going to be here on Zoom, but the public will not be connected to Zoom. They can observe the hearing on our YouTube channel. So that'll be available for both the public and the party sessions. But it's just a one-way communication. You can't make a comment when you're watching Zoom. But written comments, we also took written comments in this case. There's a link right to the page where you write your comment in, a mailing address where you can mail it in. And then there's some regulations here about how to make a comment, what we're expecting to receive, and who should be making the comments. And that's, I think, the most important thing I want to discuss here is just that we do have a caveat here in the notice that a person shall only make a comment on their own behalf. And what that means is that I want to be able to see that an individual made the comment, and it's not someone else making a comment for them. And now I understand there's maybe reasons why, for, health reasons or, disability, that someone may have to help someone make a comment. And there's really nothing wrong with that. But what comes up usually is petitions, and petitions get very tricky because a lot of times I'll just get a list of names. Like, I talk to all these people and they're all against the and they're all against the project. Well, I can't really accept that as a valid petition. It needs to pass just a test of reasonableness, that I can see that these are people who really meant to use their opportunity to comment by just signing a petition and handing it back to someone. There's a process by which the document itself on its face should provide me enough assurance that that the commenter freely and knowingly agreed to another person offering their comment, and that they agreed to forgo the opportunity to file their own comment. And then if there is a petition, that it should be filed with a sworn statement, or the person could bring it to the hearing. That's another opportunity. They can swear that they collected the comments, they had custody of the document, that they can explain how how the petition was solicited and processed and retained. So if it's kind of a squishy standard. I know, and it has to, it all depends on what I receive, but I have to have enough assurance that there's the whatever is being filed, it's real comments from real people. There's been some history. By having the standard, we've prevented some situations that other state commissions have had where they've accepted comments where then people complain, I never made that comment, this person stole my name, or I didn't really intend to file this. I'm trying to prevent that. I want to make sure that comments I give the commissioners were intended for them to be received, and people understood that. So this has come up a number of times. So I just wanted to flag that especially for the town, because you may be, presenting and gathering people to participate. There are some standards in the FMO about party participation in the public side of the process, and it's pretty limited. It's just that the party can essentially advertise the process, give people a heads up of how they can file a comment, but they shouldn't be doing it for people. They shouldn't be an intermediary between an individual member of the public and the public comment process. So there's some specific language.
So you're saying the three of us then would have to hold back from the public participation?
That would be, yeah, I would encourage you to do that so we don't have any issues. And I think, if you wanted to, whatever you want to say, if you file it in your direct, just
Okay.
make that the complete statement of your position on the case. So I'll leave it at that. I think that's the safest bet. And I really do like to keep that separate between people who are participating as parties and people who are participating as members of the public. So because you are intervening, yeah, and you're going to be representing the town, you should be filing your testimony in that way. Now, if you'd like to speak about your individual opinion on the case, I mean, I'm assuming you're pretty much in line with what the town believes. So I don't think you necessarily have to, but it's probably better if you just want to have a separate section of your testimony saying, this is my personal beliefs. That's
Okay.
fine too. But that's just to make a clean break between the two. But I did want to.
Judge Newmark, I'm sorry,
Yes.
but, just so I understand you correctly, so we could make comments either during the public hearing or in one of the other segments, I guess, when you're allowed to make comments online on your website, but you're saying they would have to be coming from us as individuals, like something specific to our individual situation, our particular piece of land, or whatever the case may be?
Well, I think you run the risk of someone complaining about that. I've allowed that in the past where if you're speaking solely, so let me, there actually is a pretty big bright line here. So if you are filing as a party, if you file testimony on behalf of the town, you should put all of your ideas in that testimony. If you're a witness in the party session, you should put everything you want to say and that the commission should hear, that you think the commission should hear in your testimony, in your written testimony. And that's in the FMO, and I don't know why I'm not finding that. But and then in addition, if you're not a witness but you are connected to the town, you can, if you come to the public session and you say, I am only speaking on my individual behalf about my property, and you give your opinion on the case, on the project. I've allowed that before. Now, public comments are subject for a request to strike from the applicant or from any other party, and I'd have to review that and see if it's appropriate. If they do complain, then I'd have to review it and make a decision. So, none of that, this is all theoretical now, but there would be an opportunity for the applicant to say, no, you went too far. You should have filed that in your written testimony. So to avoid, I'm sorry, you should have participated, and filed that in writing. But to avoid anything, if you are testifying in the party session, you must put everything you want to say in your written testimony.
Okay.
No.
I have one. Oh, go ahead. Were you
Go
going
ahead.
to speak
I'm
there?
sorry, I have the cavalry getting all excited here because I'm sitting here quiet. And my
Oh.
apologies.
Yeah, no, it's fine.
Uh, can you let us know as soon as you can when and where that meeting will be? I've been trying to, at every town meeting, I've been trying to give them an update on where we are with the whole process. And that's the only outlet that I have. I mean, we can have a special meeting, but people are very concerned here. Obviously, that's why I'm here. So
Yes, yeah, and I understand, it's an important topic for the town.
And Your Honor,
Yes.
it was mentioned that there are 3 people in the room for the town. I'm not sure that all 3 entered appearances or will be representing the town. Could we just get clarity on that?
Okay, yeah, so they did, court reporter got their names, but yeah, you're correct. So right now I don't have the other 2 people on the service list. So in terms of representing the town, what's your intention I mean, you said that possibly you'll have experts. What do you think, who do you think will be testifying on behalf of the town? Will it be all 3 of you?
yeah, I guess, yes, that would be.
Is that a yes for Aaron?
Well, that's when we entered the intervening, we put down the town of Morgan, right?
Right.
The board members of the town board, and the members of the land use plan commission.
Okay.
You need specific names? Is that
Well,
what you're asking for?
no, I don't think at this point. I mean, the people who you present as witnesses will have their written testimony filed, so we'll know who's
Right.
going to be a witness in the case at that point. But in terms of the service list, sort of the town representative for the procedures here, so we just have you, Lori, right now as the
That's fine.
contact.
Mhm.
So you guys can add more people if you want, or you could be the go-between if you want to just distribute the documents you get on your email to everyone else.
Well, if that's what this is for, is just distribution, I mean, then yes, I would like them to all come through me so I don't miss anything, or
Mhm.
if they happen to ask a question and, I mean, they're both very good at letting me know what's going on, but just in case something should happen.
Okay. So, I mean, what I'm hearing is that you'll be the point person for us.
Correct. Correct.
Okay. Yeah, and I don't know If you do engage an attorney for the procedures here, they'll need to file a notice of appearance and get on the service list as well.
Okay,
But it didn't sound like you had that wasn't something you were considering at this point.
right. And can we do that at any time?
Yeah, there's really no time frame for that. Sooner the better, of course.
Yep.
But yeah, I would look into that now if you do want to think about it. Certainly you'd want an attorney. If you are going to engage an attorney, I'd recommend you could do that before your direct testimony so that the attorney's on board with what you're saying there. But
Sure.
so I don't know
As
if
you know, oh, go ahead.
go ahead.
I was just gonna say, you probably have already figured out, the town doesn't have as much money as the applicant, so. It's a little difficult for me to spend all this money on something that, the town just, basically doesn't want. So we're trying to do, what we can, within the walls of the town hall here, so.
Yeah. All right. So let me just direct you. So on the FMO, it's section 7, and there's 4 parts to it. It actually does answer a lot of your questions. I just forget that I wrote it. And it does involve, it does show you that to what extent a party can be involved in soliciting comments or basically advertising the public process to the public. And I do have this number 4 here does say, a member or of a membership organization admitted as a party or a resident of a governmental unit admitted as a party may participate in the public hearing session as described in the notice of hearing if that person participates on their own behalf and not as a representative of the party. But the other caveat is that if you are filing another place in this document says if you are filing testimony, you can't appear at the public. You can't file a public comment. So those two things are interacting. So keep that in mind.
Okay.
All right.
Judge Newmark, this is Karen Nelson Kispert again. During that public hearing, is that anyone, I'm assuming, I guess it couldn't be a party to the case, so it wouldn't be the applicant or a party, right? So it's just members of the public, and it's just completely one-sided. I mean, if they haven't submitted something in writing, they just stand up, they say their comment, that's it, and then it moves on to the next person.
Yep, that's it. We got them all. I have maybe 100 of them on YouTube, so you can feel free to watch them and see how it goes. Yeah, so I just get your name, swear you in, you make your statement, and we move on to the next person. And yeah, usually goes pretty smooth.
But the public hearing is different than any of the other comments provided because that becomes part of the record that the commissioners need to consider. Is that true?
So anything that's filed according to the notice of hearing will be a comment that potentially will go before the commissioners. So for this case, we just had this rate case with Madison Gas and Electric. So when the document was issued on August 19th, we started taking public written comments. So when the day that the notice goes out, this link goes live, and anything we receive between August 19th and October 2nd gets filed on our system. Then I review the comments. And what I do is I put them in an exhibit called a comment exhibit. And the documents, the comments that I've put in the exhibit are the ones that the commissioners read. So I'm going to review them for duplications mostly. If someone just hits send twice or says the exact same thing, in another comment by the same person, I'll only give one of those to the commissioners to read, as well as like any petitions that don't meet the standard that I described before, that those won't be in the public comment exhibit. So it's it's a pretty lenient standard. I want to give people a chance to speak. but there are some criteria. So there's some vetting that I'll do. And then, but basically, as long as you get those comments in the time frame that we've set, and they meet the standards that we have, the commissioners will have them available in the record. So like I said, so in this case, it'll be the same in your case here. There'll be a link to our website, and there'll be a mailing address, as well as the public hearing session, the live uh, meeting that we'll conduct.
Thank you.
Okay. All
And at the meeting that the public meeting that you're going to be having, is that who is there? Just the Public Service Commission or?
So what we do is I'll be there, the public service PSC staff, several of them will be there, court reporter, and I also require the applicants to be there so that they can answer questions to with members of the public. It's not something we don't do a formal presentation at the beginning. We're not describing. We're not doing a debate or sort of a position statement portion of the hearing. Basically, just there to get people's opinion. But if people have specific questions, especially about how the project may affect their property, we have staff and the applicant staff to be available to answer those questions. They'd be done offline, uh, probably out of the hearing room, so we don't have interruptions. But then when a person gets their answers, that's when I recommend they ask their questions first, get their answers, and then come up and make their comment with the answers in mind. So, I mean, it's one type of comment. It's a valid comment to say, I have all these questions and I don't feel comfortable with this project. It's not right. I don't agree with it. There's a lot of things I don't understand. That's one way to make a comment. Another way would be to say, well, there's 3 questions I have. Let me get the answers first, and then I'll go make my comment and tell the commissioners, well, I don't like the project, but I've learned something now that makes me like it less or like it more, or maybe there's something can be done to help my situation. Like that can be um, described. It can be that conversation can be had before the person makes their comment, and then they can make a better informed comment to the commission. So there will be time for that to take questions sort of out of the room, offline at the hearing. But not on the record, not there's no kind of debate, question and answer session.
Oh, okay.
Mhm.
So it's just kind of a one-sided thing.
Yeah.
Okay. So then, let's see. Lost my train of thought. How long will that you usually
Yep.
take?
You're asking good questions. So our practice is that we'll do a session in the afternoon and one in the evening. So just like the notice you see up there, we started one session at 2 p.m. and we basically, depending on how many people are there, we'll go until we're done with the people in attendance. And then we'll wrap up, we'll go into recess, and we'll start again at 6, and we'll do the same thing. We'll take new comments from new people and go until we're done, or until we ran out of time for the building of reservation. Sometimes the building kicks us out, but essentially it's the set times are the beginning of the sessions, and then we'll just run until we're done, and make sure we get everyone a chance to comment. If for some reason we have to leave before everyone's actually gotten a chance, there'll still be the opportunity to file a written comment. Usually there's a couple of days after the session. So this one was the 30th of September. We had the meeting, and then comments were due October 2nd. If there's an overwhelming crowd of people that we couldn't get in time, I can extend that deadline so people have more time to file. But usually it works out. I mean, my experience is that this is plenty of time to get people to speak who want to speak. They can also, like I said, we'll also have forms for them to fill out at the hearing. They can just write their comment on the form and hand it back to us. And I'll upload those to our system and they'll be part of the public comment exhibit. So all the commission's just going to read all these comments, no matter what form they come in. There's going to be a transcript of the spoken comments, and all the other comments come in writing. So basically, they're all treated the same. They all look the same to the commission, whether they're spoken, whether they're presented orally or not. The commission is going to read those comments in the same in the same way. So so writing the comment, it doesn't really have any detrimental effect on the person who's making the comment. So that's always an option, just to write out your comment if for some reason you didn't make the hearing or we didn't have enough time to get to you.
Mhm. Okay, so then do you just take specific comments to the three people that are making the decision, or do all the comments go there? I mean, like, you filter everything through and then take it to those three individuals, or how does that work?
Yeah. So let me show you in this case what we did. Let's open here. So it's the same case we were looking at before. So I create the public comment exhibit and staff helps me with this, but so it's basically just a list of the documents on IRF that were submitted as comments. And these are the ones that so commissioners get this document and then they can link to an individual comment and see it. So this one, so this one's from 350 Wisconsin. So they actually just submitted their comment online.
Mhm.
But most of these comments from the public are through our public comment website, and they'll look like this. We just take name and city and state right now in terms of the identifying information. It's going to be in the docket that we want it to be in, and it's got a couple of disclaimers, and then you get to write your opinion. There's a lot of space here to put an opinion in. And then when you submit it, you're affirming, by submitting the comment, you're affirming that the comments are true and correct. That's your knowledge.
So that's just like, oh, sorry.
Yeah, no, go ahead.
So that's just like the regular comment section or comment time that we had. That was up until I think the 19th, right? It's the same kind of thing.
I'm not sure I understand what you're saying. I think so.
Clerk Morris here. I think she's talking about the environmental assessment that was open to the public.
Okay.
Mhm.
Yeah, so that's different. And so the comments that are going to be before the commission are only the ones that are going to be when I send out the notice of hearing.
Okay.
And when this deadline is set. And then you'll get this link.
The
So
link. Okay.
it's only in that time frame that I'm going to put those comments into that document that you saw.
Got it.
Into this document. Now there's other comments. So those are comments that, and if you see the comment disclaimer here, so these comments are being accepted in lieu of testimony at the public hearing pursuant to the notice of hearing. But if you look at so there's also the environmental review comments, environmental assessment comments that the commission staff is collecting in order to do their review of the environmental impacts. Staff is using those comments, and it's a different comment period, and it's pursuant to the letter that they sent out.
Okay.
So those comments don't go before the commission. It's just used by staff. So that's an important distinction. And yeah, if you want to let people know that, that's perfectly fine. That's exactly what you should be doing in terms of, informing people about the process. So let's see. So we did have the environmental review letter came out, and it gives people deadline of September 19th. So if you go on IRF, this is the CMS page, you look at comments now, there's a whole bunch of comments, 75, that were collected the 23rd. Well, okay, so these were mailed in, so they might have gotten in, so, but they might have been actually filed. We've received them by the deadline. Let's see. Yeah, 19th was when we got it, but it got onto IRF on the 23rd, but that's okay. So these are all comments sent in response to the staff's letter. And that's fine, but staff's going to use those and then they're going to they're just going to stay here. They're not going to go to the commission. Commissioner is only going to get the ones that are filed pursuant to the notice that I'll be sending.
That you sent, okay.
Mm-hmm.
Yeah, I did see a few of them that got tagged that were, and then I guess I didn't understand why those few got pulled out of there, but I think that you must have read those, or your staff must have read those. I think Heather.
Sorry. In the Fox Solar case?
Yes.
Okay. Yeah, I'm not sure. I mean, if they weren't filed in the time frame, then that might be an issue with staff. I don't usually get involved with staff's handling of that because it's their, it's their work creating the environmental review. But it looks like there were 75 comments put on IRF for that time period. And they should at least get onto IRF. Now, what staff does with them, it's another issue, but the filing itself occurs on IRF. So if you've mailed it to us or if you've filed it using the comment link, whatever instructions are in the letter, if it was sent to us properly, it should be on IRF at this point.
Okay. Okay. And Erin has to leave to
Okay.
get her children, so she's gonna bug out.
Okay. Was there anything else we need to talk about?
Yep, you're welcome. I don't, do you want anything?
I don't have anything else.
Okay. Okay. I think we're
All right.
good. I want to just thank everyone for having this for us. You're probably used to going over this a million times already, but it's been very helpful and I appreciate it.
Yeah, definitely appreciate all your patience with our questions, Judge Newmark.
Yes.
Well, thanks. No, I just hope we can address issues before we have any problems and get your questions answered. That's certainly to everyone's benefit. So I appreciate you asking the questions and engaging with us now. And don't forget that you can refer to the commission staff attorneys for any help, procedural help. If there's issues, they can relay questions to me if they need my assistance with that. But the commission staff attorneys are your first point of contact. And if you have problems filing documents on IRF, feel free to call the records management unit.
Yep.
That's on the FMO as well, the contact information for that.
Yep. Okay.
And I'll send out those Word documents to everybody.
Yeah, it'll be great.
All right.
Thank you.
Okay.
All right.
Thanks.
Let's go on the record then. So we discussed the FMO and we thoroughly reviewed various pitfalls that new parties do face and hopefully answered some questions in advance of any problems. So I just appreciate everyone's patience and really providing us some good information and some good preemptive topics here to organize the case. So I appreciate that. So with that, I think we're good. We have our issues, schedule, and facilitating matters set, and the parties were set already. So at this point, that's all we have to do today. Thanks very much, and we're adjourned.
Okay.
Thank
All
you,
right.
Your Honor.
Yep.
Thank you.
Get well, Judge Newmark.
Feel better.
Thanks. Yeah.
And wait, if you could stay on.
Sure, no problem. Just turn off the live stream. I have so many windows open, I can't figure it out anymore. It's all hung up.
$92 for the Xcel Energy statement. She must be using the air conditioning a lot.
Hot in Minnesota still?
It's normally warmer there, yeah. And then when it gets cold, it's colder there. It's really kind of bizarre.
Oh,
But
right.
somebody explained to me they don't have lake effect like we do here.
Sure.
So when it's cold, it's colder. When it's hot, it's hotter. So plus she has the dog now too. So
Oh, yeah. You gotta make sure the dog's okay.
well, she can't just close her windows and go to work, suffocate the
Oh.
dog. I told her that was one sacrifice she was going to have to make, and she's like, "I'm okay."
So I can't figure out how to turn this off. It's not.
That's okay. It's not important. I just wanted to see if you had are you thinking a short one again tomorrow, or do you know?
Oh, yes. Yeah. There shouldn't be anything
Okay.
controversial with that one.
Okay.
So-
All right. I'm good then.
Okay, excellent.
All right.
All
Go
right.
sleep. Go to bed.
Yeah. That's it.
All right.
Take care. Thanks.
Bye-bye.
Bye.